Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Michael and Anita. So, maybe Michael, you can start off, tell us a little bit about yourself, and we'll get going.
Oh, great. Well, thanks for the invitation, first of all. Um, my name's Michael Cochrane. I'm a lawyer with Browdy Thorning in Toronto. It's a mid-sized firm. I do primarily family litigation, some civil litigation, and public policy work. And proud to report that as of this month, I have celebrated my 45th anniversary at the bar. 45 years ago, I got called to the bar.
Well, it's certainly a long time there, so congratulations on that.
Thank you.
Uh, Anita, I don't think you're quite at that vintage there, but you can tell us a little bit about yourself as well.
Thank you, JP, for having us on the show. And Michael Hardy, congratulations. 45 years is a truly remarkable accomplishment. And it makes me feel like junior counsel with my paltry 32 years at the Ontario Bar. I also practice in Nunavut, where I'm really junior counsel. I was called there in 2014. I am a mental health law specialist. I practice both civil litigation and criminal defense, where mental health intersects with people's legal rights. And I also work in health law more broadly in issues of consent and capacity. I have my own firm, Anita Szigeti Advocates, or ASA, like the aspirin, a little firm in downtown Toronto.
Perfect. So I know I've had both of you on for different issues, but to know the talk of right now, and unless you're living under a rock or perhaps not as paying attention to what's going on in the Law Society, they had the recent CEO pay scandal, and perhaps maybe Michael, you can give us a quick summary of what kind of has happened, especially for maybe some of my students who may not be as paying attention to what's going on, and tell us kind of in a nutshell what happened, and then Anita, if you want to add anything afterwards to it, and then we can go from there and discuss this issue.
Yeah, so just by way of a background on this, I ran for bencher in 2023. I was at that time very worried about the way the governance of the Law Society was evolving. There seemed to be these two slates that had come forward, and the one slate had I guess would be described as an ideological point of view, and the other slate, called Good Governance, had more of I would call it a righteous or self-righteous almost approach, that they were going to stop the ideological campaign, the ideological slate, and they would, if victorious in the campaign, they would bring so-called good governance to the Law Society and to bencher life. I didn't think that either slate would be 100% successful. I wasn't obviously attached to either slate. I was running as an independent. I didn't think that one slate or the other, as I say, would be 100% successful, but I thought if some from each side arrived at a convocation or arrived as benchers, that there would be a lot of conflict and they would need some independent voices in between to, in a way, kind of mediate or help people find common ground. So that was really the reason I was running, and I made a point of that throughout my campaign. Nobody's going to be 100% successful. We're going to need some independent voices there. I want to be one of them. Little did I know that it would be quite different than that the good governance slate virtually swamped the election. They elected all of their candidates and now are in charge of the Law Society. So that was a couple of years ago. That was in 2023. And here we are 2 years later looking at this what's being called the compensation scandal, or what I've been referring to as the compensation debacle, where we find out that the person who is the head of the Law Society body, the bureaucracy, if you like, the CEO of the Law Society, Diana Miles, who had been there from 2018, had received a pretty significant increase in her compensation. And it was done in a way that we can get into the details of. It was done in a way that was not in conformity with the traditional way the decision making around compensation had been made at the Law Society. So she got this increase, and the person who was treasurer at the time, Jacqueline Horvath, approved that on her own. Later on, many months later, after Ms. Horvath was appointed a Superior Court judge, it was revealed that this compensation increase had been made, a considerable one. It put her in over $1 million of compensation. It had been made, and it had not been approved by convocation. So that made when that was revealed, that made a lot of people at convocation very uncomfortable, because when Diana Miles was hired in 2018, or she at least elevated from her position in the Law Society to the position of CEO, her original compensation agreement was approved by convocation. Every year between 2018 and 2024, Ms. Miles sought and received a bonus. Each time that bonus discussion came up, it was, I would say mildly, it was controversial. But in any event, each year between 2018 and 2024, she received a bonus. Each of those bonuses were approved by convocation. Somehow, and this is the mystery for me, somehow the compensation committee that was in charge, and I use that expression in quotation marks, in charge of making these compensation decisions, that committee, that subcommittee within the Law Society, comprised of benchers, both lawyers and lay people, discussed this compensation. Jacqueline Horvath, as treasurer, made some submissions to that compensation committee and assured them, and I'm abbreviating this now, assured them that she had the authority to approve Ms. Miles' new compensation package on her own without approval of convocation. They said essentially, great, go ahead. She did it and signed off on it, and then was appointed to the bench. Now, as I say, later on, that process was disclosed to convocation. There was upset about it. It was particularly when people realized that they had never been asked for their approval of this compensation package. And there was a decision to appoint a fact finder, someone to do an investigation around this. The Law Society retained retired judge Justice O'Connor, very good judge, very good person to bring in, I think, to do this fact finding. And he did a report, and the report is only 67 pages long. I read the report very closely, and I read his recommendations very closely. It's only 67 pages long, but 35 of those 67 pages are an appendix. And the appendix is really the guts of it. It's in the appendix that he says, here's really what happened. He does a timeline and analysis of how this decision-making unfolded, and where there were some pretty serious lapses in judgment, and I would say really, I wouldn't say misconduct, but there was the standard that I was expecting from certain benchers, I think was not met. So it's a good report. He makes some recommendations. The recommendations, aside from being astonished by what he uncovered about this process for the decision around compensation, the astonishing part of his recommendations is that I think anybody who read them, or anybody who knows anything about governance or anything about running meetings or committees, would say This is like governance 101. Keep minutes of meetings, have terms of reference, tell benchers what their jobs are, monitor. I mean, it's like so simplistic. It's just like, honestly, you could have copied it out of a first year political science book or a first year governance book. That's what we got from Justice O'Connor. And it's not that he's letting anybody down. It's the fact that the Law Society apparently has been operating in a way that is totally different from what any of us would have expected. So he made the recommendations. So I read it closely. I wrote an article about it because to me, I couldn't figure out if this story was a whodunit or is it Keystone Cops? Because you're only left with one question really at the end of it all for me. Why? Why did they do this? It was clear that Jacqueline Horvath did not have the authority to do what she did, and yet she went ahead and did it anyways. And the other why is Diana Miles, given her position as CEO, why on earth did she allow this to happen, given what she knew about her previous approvals of compensation by a convocation? So there's the mystery for your listeners. Why? Why did this happen? And what have we learned because of it?
And thanks for that, Michael. And Anita, I know you've also written and discussed this issue, but whether it's the O'Connor report or anything else in terms of the information that we've gotten from there, anything to add or your own slant on what you've read about?
Sure. Well, I want to thank Michael for that very succinct, very accurate, very fair sort of telling of the tale of what happened or what we know. I should say also that I did also run for bencher, but back in 2011, when we only had independents, we didn't have this slate versus coalition thing. You just ran as a person who was interested in donating your time to assist in governing our profession. And I had, I think, a budget of maybe $500 or $1,000. I hand printed buttons. And I did pretty well. I got like 2,800 votes in Toronto. If enough people had gone to the bench, I think ultimately I was like one step away from being a bencher for about 5 minutes before the 4 years ran out. And I was very excited to get in by attrition. And then I found out that some people were accessing $50,000 and $75,000 budgets to run for bencher. So ever since then, I've just had an interest in watching bencher elections and have some views about how we can improve the election process and the governance process, including capping the kind of money people spend on these bencher election campaigns. And I would go further and say that our elected benchers should not have active judicial applications in, because what's happening is everyone who is a bencher wants to be a judge. Like we can see it, since this group got in 2023, 5 or 7 of them or more have become judges. They're all interested in being judges. And I don't think this position should be used as a stepping stone to the bench. You can apply to the bench before, you can apply to the bench after, but suspend that application when you're governing the profession so that you can fully and fairly immerse yourself in governing, in good conscience. Anyway, so this bencher election in which Michael was a candidate in 2023, JP, as you know, we've discussed this together, you paid very close attention. I frankly thought was an embarrassment to the profession, respectfully, in terms of the tenor, the tone, the infighting, the factions, the anger. And I heard Michael use the word self-righteous about the Good Governance Coalition, and I think that's exactly right. So part of the problem of what happened here is the people who all got in, the Good Governance Coalition swept it all, and they came in on their high horse, the self-righteous attitude, they were going to fix everything, and they were the only solution to all our problems. Like if you cast a vote for someone who was not in the group of 40 that they put together, the sky would fall. And so that's what we were told. And we were told, look, you have to vote for these people to save the profession from the other people who were cast as bad actors. And all of this is profoundly unhealthy for the profession. So what happens is people are elected, there's a new convocation. And then the 60,000 lawyers in Ontario and 11,000 paralegals that the Law Society governs generally promptly forget about the benchers and what happens in Law Society. They go off, they do their thing, and we for 4 years, nobody cares till there's the next election. All of a sudden, 2 years into this thing happens. And the profession woke up. Everybody woke up. People are talking about it at the water cooler. I don't know one Ontario lawyer who thinks what happened here is okay or can make sense of it. Anyone who has ever sat on a board, I've sat on 5 boards over the last 15 years, knows how a CEO salary increase is approved. Anyone would know that it goes to the board to approve. So how did these lawyers with their pedigrees, who all should have some governance experience, how can they assert that they didn't know? And the O'Connor report suggests that when people involved on the compensation committee were interviewed, they profess not to know how this thing works, even though some of them had been directly involved in the years before. And so, that's very difficult to accept that they just simply didn't know that it should have to go to convocation. But there's also suggestions that they were actively working on trying to figure out how to keep it out of convocation. That's a slap in the face to the profession who has elected these benchers to form convocation and make these decisions, these important decisions. So to have a couple of people actively working to keep such an important decision, and perhaps other decisions, we don't know, out of convocation, away from the elected benchers to weigh in on and make these decisions, feels like a betrayal. And it feels and smells and looks like actually terrible governance. So the Good Governance Coalition brought us some very bad governance, and that left the profession asking, how do we get here? What do we do about it? And I agree with Michael. The O'Connor report suggestions, they say things like, set out a clear process for approving the CEO's compensation. And stuff like that, it worries me a little bit because now, of course, the Law Society has held their April convocation and they voted in favor of setting out, clarifying clear rules around this. But it's really a red herring because, as we all know, the rules were always very clear. Just because some people profess not to know them or didn't want to follow them or purposefully strayed from them doesn't mean there was any problem in the rules. So now the Law Society, it feels like we're being gaslighted a little bit because we're being told, don't worry, we're going to review all our bylaws, we're going to clarify things, we're going to get some more training, we'll get experts on governance to help us make things, more transparent. But that's not the issue. The issue that got us to this place is that we had people choosing to act unilaterally and bypass the process. And that has created a huge problem in that the profession has lost trust and confidence and faith in our governing body. And that's a big problem for the Law Society, because in order to effectively govern us, not only do they have to have the trust and confidence of the public, whom they're there to safeguard from bad actors in the profession, but they must have the trust and confidence of the profession to govern us, because otherwise they're going to come into our offices and say, your trust account, you've misplaced 3 cents, and we're going to send you a warning and a letter, and we want to hear from your bookkeeper and your accountant. And we're going to turn around and say, well, you lost $1 million or, gave it to your friends or your former clients, and you didn't do anything about that. It's okay when you do it. So, there really is, it's a moment in time where the profession is disappointed, hurt, angry, concerned, alarmed, and is really keeping an eye on how they're going to address what's happened here. So it's a critical moment in time that, in my view, has had a significant side benefit, although unintended side benefit, in engaging the profession in issues of governance of our governing body. And I think and I hope that it will make the next bencher election something that members of the profession are more involved with and have a more sort of clear-eyed view to support independence, like Michael, in getting a seat at the table and to avoid another train wreck of these warring factions that politicize and polarize the Law Society.
Now, I mean, on that, I guess no, for the general benchers who wouldn't have been on this compensation committee, and no, and again, it's about a year or so into their term, and some of them are freshly elected. So, I mean, is there anything in the report or from what you've looked at as to, is it fair to characterize every bencher as part of the problem, or were they just unaware of what was happening behind closed doors, and especially there was a treasurer then that's elected subsequently, right? Justice Horvath then goes on to the bench, and it comes a few months later of what actually unfolded. So I mean, Michael, is there anything to kind of look at it like, are there anybody involved at the Law Society, I mean, even as well the staff, not just the benchers, that could have not been part of knowing exactly what's going on, or is the concern across the board with pretty much anyone involved with our governance right now?
Wow, Anita, you touched on so many really valuable points that I want to come back to. But JP, this question you've asked is really, should we tar the whole group of them as poor governance because this one committee kind of blew it? That's really what it boils down to. And I would say O'Connor's report doesn't lead us to that conclusion. It doesn't say that other people drop the ball, but it does raise the question, and I think Anita touched on this. It does raise the question of what else is going on down there. If this is the way the compensation committee was operating, what would make us think that any of the other committees were operating in a different way? And so when she talks about a loss of trust, that's where my loss of trust is, because now I have a question mark about everything that's been happening at the Law Society the last couple of years. But let's just look at that compensation committee. We can't say, oh, well, these were just new benchers who were appointed. These were experienced benchers who had been around for a long time. And, some of the details of it, Sid Troyster, who's been a bencher forever, very, very good lawyer, very, terrific lawyer. He's been around for a long time. Sid was on that committee. And for some reason, and this contributes to the little sort of whodunit mystery component of this debacle, Jacqueline Horvath, as treasurer, asked Megan Shortrid to be on the compensation committee. There was a couple of people there were short people on the committee. So when it got to this point of needing to discuss Miles' compensation, Horvath asked Shortreed to be on the committee. Okay, Ms. Shortreed had been around for a while. She'd been elected. And she had disclosed that back in 2018, she had actually been a lawyer in private practice who gave legal advice to Diana Miles about her original compensation agreement. So Miles was Shortreed's client. She finished that advice, and they had no ongoing relationship as far as we know. Shortreed becomes a bencher. Bonus requests go forward to convocation, and as I mentioned earlier, approved year after year after year. Shortreed is a bencher. It no longer really mentions that she used to be lawyer for Miles. Then she's asked to be on the compensation committee when the big discussion of an increase in compensation comes forward, and does not disclose, as far as we know, to that group that she used to be the lawyer for Diana Miles. So, as I say in my article that I wrote for Law 360, technically, yeah, I guess that's okay. But was anyone aware of the optics around this, that a person was sitting in approval of a former client's new compensation agreement? That just looks awful. And when I've explained the situation to friends of mine who are non-lawyers, business people and otherwise, and I say this is how it unfolded, their response to that is, but you guys are lawyers. Aren't you the ones who would stop something like that from happening? Say, oh, no, lawyers have always got 10 reasons why you shouldn't be doing something. Why weren't lawyers, experienced lawyers who'd been benchers for a while, responding to all these red flags? They weren't. And that compensation committee, in the description by Justice O'Connor, was they did not do their job. They did a poor job. And I can tell you, if you read through the appendix to that report, his report, there are lots of people saying, I don't recall, I don't recall, I don't recall, I didn't read that, I didn't know that that's what the document said, I wasn't aware of that. It's really hard to believe when you read through the details of his report. So should the whole group of benchers in good governance be tarred with the same brush? Not based on what O'Connor says, but certainly the compensation committee should be tarred like that. And certainly, I think people are justified in asking themselves, what else has been going on down there over the last couple of years? And
JP,
I would say this going forward: do we have confidence in this group making decisions going forward if this is the way they've been operating in the past? So,
JP, if I can just weigh in on the heels of those thoughtful comments by Michael, and the conflict of interest, or the appearance of the conflict of interest of someone who was the lawyer for the individual whose salary is being revisited and reconsidered, and is now a member, a director of the organization that would be paying the increase. I mean, it's so apparent and it's so glaring that the lay bencher on that committee raised a concern about the conflict of interest and asked the treasurer to remove the individual whose former client Diana Miles was, right? So when you ask the question, should they all be tarred with the same feather or whatever it is, there were people, the non-lawyers on the compensation committee, the paralegal bencher, first raised a concern about the quantum of the proposed salary increase. And she kept asking for more evidence of the transformational role of the CEO that would warrant this huge, many hundreds of thousands of dollars of increase. And she, according to the O'Connor report, she wanted to quit the compensation committee. She wanted to resign, didn't come to meetings, didn't come to 4 or 5 monthly meetings because she was trying to resign over this issue. That she didn't think that this was a meritorious quantum of the raise. And then the lay bencher said, well, Megan Shortreed has a conflict of interest and she should be removed from this committee. So there were dissenters, usually the non-lawyers. The lawyers on the compensation committee, I think, had problematic involvement in that committee. But the non-lawyers on that compensation committee, held up their hand and said repeatedly in different ways, I have a problem with what's happening. But they were ignored or strong-armed into, I don't know what happened, but the dissent was not tolerated. It was not allowed to come out in the open. There was no debate. There was no discussion. There was no conversation. They were somehow silenced. That's a cultural problem within the Law Society. And that's a problem for our governing body that, again, escalates the lack of trust and the lack of confidence. And it contributes to the lack of transparency. So I think there's a cultural problem. I think what we worry about as members who are governed by these people is, how toxic is that cultural problem? How do they tolerate no dissent? Are there warring factions? Are there little in groups and buddies and cliques? Are all the decisions being made by a handful of people who are the powerful people within convocations, such as some of the lawyer members of the compensation committee? And the biggest problem now is, of course, that these individuals who had the most problematic conduct or contributions on that compensation committee have not stepped off, have not resigned, have not taken a pause while, some of this stuff is being looked at or sorted, but rather continued in their roles on the compensation committee, which I think has now been dissolved pending, some of that specific issue being reconsidered. But they are continuing in important roles on the Audit and Finance Committee as the chair of that committee. I think Sid Troyster is the chair of that committee. Megan Shortreed is on the Governance Reform Committee. So she's part of the group considering how to reform the governance of the society. These people continue in very powerful roles, notwithstanding what's just occurred. And that does not build trust or confidence of the profession. While all of this is being revisited, I think it would be important to acknowledge that there was some problematic stuff that happened, and look at it and hear from the society that that while they're sorting this stuff out, these same lawyer members of the compensation committee are not in charge of fixing the problem that they were a part of, just based on the reports that we've seen. So I think it's a many-layered onion. Not everybody has had problematic conduct. Some people have had really positive contributions where they were trying to whistleblow, trying to do the right thing, trying to raise alarm bells, but they were not heard. So I think there is a cultural problem. And a new report has come out. I think it's the Hansel report by Governance Advisors. And that report is very plainly written. I would encourage everyone to read it because it identifies in a very accessible and readable way the cultural problems that they glean from the findings in O'Connor. The appendix in O'Connor, I agree, is the important part, and the footnotes. There's some really important things in the footnotes.
I agree with everything you've just said. And I just wanted to pick up on something else, JP, that you mentioned, and that is about Law Society staff. And we have to go back now to this slate conflict, where the original slate that was trying to stop essentially the statement of principles from being forced on members, when they arrived at convocation and kind of disrupted things, one of the points that they made was that aside from the Law Society becoming too big and I think they described it as mission creep, they were getting way outside the mandate of what a law society should be doing. They also made the point that there was too much deference being made to Law Society staff. And they were very heavily criticized for that. No. Law Society staff, they're the experts. And your mistrust of Law Society staff is improper. And from what I've heard from some of those members who were elected as benchers, they were vilified. They were criticized and made to really feel like they were unwanted at convocation. So their point was, don't defer to Law Society staff. The Good Governance Coalition ran on the basis that they were going to change any of that. This was a time to show respect and trust and confidence in Law Society staff. So that was a component of good governance, that they were going to now defer more to Law Society staff. So what do we find out when we go into the O'Connor report? Everybody's saying, well, we defer to Law Society staff because they're the experts. And if the Law Society staff say this, then we haven't got the time or the resources to do independent research. We just rely on staff. Well, guess what? The advice they were getting from staff was, I would say, frankly, incompetent. They couldn't find the minutes from meetings that had been held in 2018. They couldn't find any of the records related to the original compensation agreement approval. And they were telling the compensation committee, and I assume Ms. Horvath, that they couldn't find these things. So there's no precedent for how to handle this matter. It was dead wrong. The advice was dead wrong from Law Society staff. So here we have the good governance benchers saying, It's time to trust and rely on the Law Society staff. They're doing precisely that, and that's why they make a big mistake. And I think there are probably a few benchers feeling quite sheepish about the position that they took, that no, we really shouldn't be criticizing Law Society staff. There are some names redacted from the O'Connor report for good reason, and a lot of what was done and said by Law Society staff was inaccurate and a big part of the problem.
Yeah, but now before we kind of look at governance, maybe generally, I think another piece to it is, that Anita kind of brought up is kind of what was the response from the Law Society, and I think that also, and it's probably a good time as well because I do want to mention certainly I would have loved to have benchers to discuss this issue. Maybe they will still reach out. I know I've reached out to Treasurer Wardell's office and hope to just have a discussion. Like previous treasurers have talked to me and my students, about the generalities of the Law Society. But I mean, I think part of the issue that I've heard is that there was like, are they going to release the report, or are we going to find out what's going to happen? They had these emergency meetings. So I mean, what about that in terms of not sometimes it's not necessarily the issue, but it's the aftermath, right? In politics, right? That kind of creates even more of what's going on here, right? And anything to add on that point there, Michael, of why aren't we hearing from the Law Society about here's what happened, here's what we've done to remedy this situation, where it's kind of dragged on for a few months before we ended up getting the O'Connor report.
Yeah, I think that people at the Law Society would say it had to do with the way that the meetings are scheduled. There was a summer delay and things were, didn't really come forward as quickly as it could have. I've been waiting for someone to say something as simple as, wow, we dropped the ball. Boy, did we ever drop the ball on this one. Sorry. And we want to assure you that that's not the way we usually do business down here, but we've not heard anything to that effect.
So, JP, I think you may know, and in the legal media, there are two organizations that I'm involved with, the Law and Mental Disorder Association and Women in Canadian Criminal Defense, who both wrote letters advocating the release of the O'Connor report. So the sort of first scandalous moment was, the messaging from the Treasurer and the Law Society was, yes, this compensation issue has been brought to our attention, but don't worry, we've retained an independent expert to do an independent investigation, and we will keep you updated as soon as we hear back from His Honor Dennis O'Connor. And we were all like, okay, that's something. And then the next round of messaging was, but you can't know what's in that report because it's legal advice to us on an employment situation and there's privacy concerns. And that's actually the moment that the profession sort of collectively lost our cool, because we were being told, none of your business, don't worry your pretty little heads about it, we'll get some help, but you don't really need to know, you don't get to know, it's not really your business what the findings are about how we are dealing with this and what actually happened. And so, the profession doesn't like to be ignored. We don't like to be told that we can't be trusted with information, that we don't have the right to know what they're doing with our money or what has happened. There was my own personal opinions, there was a way to manage the situation that would have avoided weeks and months of fallout. And I absolutely agree that the way to do it would have been, we screwed up. There was a bad thing that happened that we recognized it was bad. We don't need an expensive independent report to tell us it's bad, but now we have that and it's clear that it was bad. We really screwed up. But rather than just saying, don't worry, we'll get tutoring, we'll get help, we'll do better next time, we'll try not to repeat this exact same problem, which is where the focus is. You can come clean and say, whatever led to allow this situation to happen is a fundamental problem, a cultural problem, and we're going to address that. We're going to address how we communicate, how we relate to each other, how we communicate with the profession, and show the profession some respect. So we were hoping, as you were, to meet with Treasurer Wardle, who had agreed, to his credit, to meet with Lambda, to meet with Wicked, to meet with Fulla. This was all reported in the legal media. He had said he would come and meet with each of us and address our concerns and hear us out. And we were really glad about that. But he never did. He never did. Last minute, everything was canceled. He had client obligations that suddenly came up out of town. And those meetings never happened. And I think that's very unfortunate because the hurt and anger and disappointment and concern that the profession was voicing had to do with the fact that we are hardworking, decent, honest lawyers working super hard on legal aid tickets for vulnerable people. And we see our governing body, skirting the rules to put hundreds of thousands of dollars into the pocket of staff. And the disconnect, where is the recognition of our lived reality and how offensive that is to us, using our fees to squander these huge amounts of money when we're all just like working so hard to survive. We wanted to be heard. We needed to be treated with the respect that we deserve. And so, not meeting with us, not speaking with us, not being candid about it, not acknowledging the magnitude of the problem, the mistake, misconduct, whatever you call it, showed profound disrespect for the bar. So, you had the feeling that our elected benchers think that the members of the profession they govern are either not very smart or we couldn't care less, or we're not entitled to know how they're governing us. And all of those things fuel very bad feelings, which is not an argument in support of self-governance. And I think it ultimately risks self-governance because if there's this much animosity and distrust between those who govern us and the people being governed, that's an argument to take self-governance out of our hands and have somebody else come in and clean up whatever global mess is happening.
I would just jump in on one of the items on that list, Anita, that you mentioned of like, they don't think we're entitled to the information, et cetera, et cetera. The other one is, it'll just blow over. Just leave it. Practitioners are busy. They're trying to run a practice. They've got families. Look at the political situation in the world. All of these things that are going on around us that keep us real busy. It's hard to focus on, one big screw up at the Law Society. Because the other thing we have to remember is that I don't know if I speak for like thousands of members when I say this, but the less contact we have with the Law Society, the better.
Yeah.
We get a notice, pay our fees, get our certificates for incorporations, whatever, do our CPDs, and leave us alone. Don't send us letters. Every time you get a letter from the Law Society, your hair stands on end. And now we get this. Here we're trying to not be engaged with them, just to run our lives and hope that they're doing a good job on our behalf. And what do we find out? Not happening. So now we got another thing we got to deal with, and we got to get ourselves involved. We got to take sides. You got to be against the self-righteous good governance people who I think do feel like they are holier than thou in many respects, the way that they speak about the way that they're going to manage the Law Society. You go back and read some of the literature that was published by good governance about what they were going to do. Oh my gosh, if only it had been like that. But I was just going to say also this fine point about O'Connor, because there was, I think, some mistrust generated by the delay around releasing that report and all the excuses that were given. And it was only because there was pressure from members. People, like myself, wrote articles, and others wrote articles and wrote letters. And finally they released it. And what do we find out? It's not legal advice. They were holding that back, saying, oh no, we can't release this because it's legal advice. It wasn't legal advice. It was a fact finder report. Sure, they redacted a few names in it, but there was no reason to hold that report back, nor is there any reason to hold back any of the reports associated with this. All the compensation reports that were paid for independently, all the analysis that's been done since by Hansel and others, that should all be public and available to members. And there should be some, I think, a larger clearing of the air around this.
And that's why the annual general meeting is on September 18th at 5:15 p.m. And it's at the Law Society's annual general meeting that licensees can bring motions. And it's really easy to bring a motion. You just get 10 members of the profession, lawyers or paralegals, to sign on to your motion. And everyone in attendance gets to vote on it, as I understand it. Now, I've brought a motion once before in my career to the annual general meeting of the Law Society. That was in 1994 when I sought to end the practice, the reprehensible practice of unpaid articles that were usually reserved for international lawyers or racialized lawyers. I brought that motion for a host of reasons, including my mom was a foreign trained physician who had to intern for free. But I haven't brought a motion in 30 plus years. But this September 18th, I'm thinking of bringing some motions. And there are all kinds of things that I'd like to ask the Law Society to disclose to the profession, including what, for example, was the global dollar price tag for the fallout of all of this, because of all the reports. Like, they got all the consultation reports, they got the first set of consultants on how much they should be paying the CEO. And when lawyers like me in small legal aid criminal defense practices hear about $1 million salary and $267,000 retroactive payment, pension payments and stuff, those numbers to us, like, we wonder how they didn't notice those numbers, like how people on the compensation committee and how Treasurer Wardle, when they saw these numbers floating around, there was no red flag saying, well, that's a huge number. They probably see those types of numbers for CEOs of their clients and the corporate clients that they deal with. But people like me, people from little legal aid practices, would see a number like that as a salary for a staff member. That would be, a red flag. So I'd like to know how much all the different human resources or companies that said this is a good number or it's a too much or a small number. There were a bunch of those reports. How much was the O'Connor report? I have all the respect in the world for Dennis O'Connor. I appeared before him many, many times in my career. I trust him. I trust his judgment. I trust his report. Fair. How much was Warden Ladner's cost on that report? All of this was necessary because one or two or three individuals decided to bypass the established and well-known process of going to convocation to get the board of directors to approve a salary increase. And then what other reports followed? And now they're hiring governance consultants to tell them what a compensation committee's role is. If you've ever sat on a board, you know what the role of committees is. Committees advise the broader board. They make recommendations. How could they not know what the role of the compensation committee was? So now we have to hire governance experts to help them decide what the committees do and how to keep minutes, how to keep notes. And I think this is one of those things that makes it all the more inflammatory is this is our governing body. So they come into our offices, open our files, and if we have not taken notes of our meetings and notes of our phone messages that we receive, if we don't keep them organized in our physical filing cabinet or on our computer, and they take issue with that, we don't get to say, you know what, don't worry your pretty little heads about it, Law Society. We'll get help. I'll get some tutoring and I'll do better next time. I'll take notes next time, or I'll get someone to tell me how to take notes or where to file my file. When they come into my office, they expect me to know what my professional obligations are. And we get our knuckles, wrapped if we haven't done it. Meanwhile, we find out that their practice, traditionally and historically, has been never to keep any notes or any minutes of their meetings. And this goes back to what Michael was saying. Some of these revelations about what they're now hiring experts to help them do are so basic that it's almost laughable and it's difficult to believe. So I think there's a lot of work for them to do to regain our trust, but I'm not persuaded that they're going to do the work because although they pay lip service, they say, we know there's a problem and it's important that people trust us. I'm not seeing them doing the work to regain our trust or to treat us with the respect that we deserve. There's a lot of very smart lawyers, 60,000 lawyers, 11,000 paralegals. We are not to be treated with anything but the respect we deserve. We're all professionals and we're all very committed to serving the profession. And we should be acknowledged as important justice system participants who, deserve and are entitled and have the right to know what is happening within the walls and halls of our law society.
Now let's look at maybe going forward there, and Michael.
Can I just
Yeah.
ask one question following up on everything Anita said? Because I said at the outset, there was it a whodunit or was it Keystone Cops? It seems to be a little bit of both, but I really want to know why they did it, because I don't believe for a second that Jacqueline Horvath thought she had sole authority. I think she knew Convocation had to approve this thing. I think that Diana Miles knew that Convocation had to approve this thing because she's the CEO, and every compensation agreement or bonus she ever got was approved by Convocation. Why did this happen?
I think, Michael,
We're missing something.
I think, Michael, part of your answer is within the O'Connor report because of the inherent internal inconsistencies. Because throughout the history of Diana Miles' compensation, Mercer, former treasurers, other people had said to her, look, now's not the time to raise the issue of your compensation, Diana, because Convocation's not going to approve it. It's going to be a bloodbath, so we can't take it there. So they knew it would be controversial, and they knew that Convocation wouldn't approve it. So I think it's clear that they purposefully kept it out of Convocation. And because they didn't want the confrontation, because it was important to them to give Diana Miles that kind of money. And you see in the O'Connor report why. Because in one of the meetings, the reported conversation was Jacqueline Horvath asking, or somebody asking Diana Miles, whether there was a risk of her walking. I think, I can't remember the words, but is there a retention issue potentially? They were scared, it sounded like, that she might leave. And her reported answer in the O'Connor report was, well, I'm not going to leave right now. But if I don't get appropriately compensated for the kind of stress I'm under, then I won't stick around for long. And in the absence of succession planning, that terrified them. But again, when my bar, who deals with, prison sentences, life sentences, loss of liberty, working all night for $100 an hour, the stress we're under trying to feed our families with no maternity leave, young children, aging parents, the stresses we're under and the mental health of the profession. And we hear the CEO of the Law Society saying $600,000 is not going to cut it for the kind of stress I'm dealing with to decide whether I want a gender neutral robing room or if I want to close the restaurant or whatever other decisions. The stress is so devastating. I'm going to need another $500,000 to $600,000 to $800,000, or I'm going to have to go. And you're reading all the stuff in a report, coming at it from the kind of devastating stress that we're under day in and day out, trying to serve vulnerable client populations in the profession. The disconnect feels like a kick in the gut and a slap in the face. And it's that piece that I don't think they're mindful of, how they come off in the way that they talk about these things. And we've never had this insider look, this bird's eye view into these conversations and the kinds of things that they're deciding behind closed doors. And it's really made the profession, we're incensed, we're infuriated, and we're exercised. There's a lot of passion and anger in the profession, and I have never seen that in the context of the role of benchers or convocation in this profession. So I do think it's a deciding moment and a defining moment for the profession in how we relate to our governing body and the bigger issue of self-governance. Should lawyers be allowed to govern ourselves? Are we able to do it? Can we do it through electing our benchers, which brings us to the governance changes that this current convocation is proposing, JP, where they want fewer elected benchers and they want the Law Society itself proposes to appoint some of those benchers to a somewhat smaller board. That's a governance proposal that's on the table that they've sought input from the profession on.
Yeah, so I did want to look at, before maybe we look at that point though, is as both of you have run for benchers and been candidates in either the most recent election or a few behind it. Now, if you were in that role, right, we were looking at, look, we can't necessarily paint everyone with the same brush. But we've had this scandal, right? It's come out. There's all the reports. There are still a number of benchers who are, whether part of the good governance group, others, right, who have been in there, the lay benchers, the paralegal benchers, and there was a group that went and said we want this report released, right? That were of existing benchers. So if you were a bencher, right, if you were elected, Michael, the last time, if you were in this group now, it's exactly at the midpoint. I believe May 1st, 2025 is 2 years to the date of when the results came out in 2023. So if you were a bencher right now, I mean, how do you move forward, or can you move forward, or what would you suggest to the existing benches of how to move past this into the next half of the term?
Yeah, I mean, if I was there sitting at the table with them, first of all, I would want everyone to know that they're free to speak, that there's not going to be any recrimination or punishment from the Law Society if benchers speak. I mean, there's one thing to have confidential meetings and in-camera meetings where you need to be able to speak confidentially, but the word is that benchers were told to zip it. They weren't to discuss this matter. And I think that plays into this attitude of, if we just slow walk this thing, it'll blow over. Members of the profession have enough on their plates right now. Two years from now, the last thing they're going to be thinking about is Diana Miles and her compensation. It'll be ancient history. So I think that's part of the attitude that's there. But people should be free to speak their minds about what happened. Secondly, there has to be some public accountability for what happened. It cannot just be, oops, sorry, and sweep it on. We're going to make some changes and we'll all forget about this. There has to be some form of accountability. And I think that's up to benchers themselves maybe to discuss and decide. I don't know if people should be resigning, or if there should be some reprimand, or there should be some, I'm not saying public flogging or anything like that, but there has to be some form of accountability. And then, having said that, I think the profession really needs to be reassured, first, that this is a one-off, that this isn't happening in other areas. Because if it has happened somewhere else, they better disclose that now. If there's been some other ball dropped somewhere, get it out on the table right now and let's clear the air. But let's operate on the assumption this is a one-off. But it still has damaged trust. There needs to be some action that regains that trust from membership. And I think that comes in two parts. It's a clearing of the air around what happened with this dropping of the ball and compensation, and of also a clear demonstration to the membership that things are being implemented to make sure it doesn't happen again. And I think there has to be some accountability within the Law Society itself among staff there. Staff don't come off very well in this, and there needs to be some accountability there as well. The members are giving the Law Society a lot of money. And it's not like other businesses, and this goes back to the details about why they felt her compensation should be so high. The amount of money that's flowing through the Law Society is not the same as a business, where a business is run and they have to account for markets and profitability and everything. If you've got a $400 million business that makes a product or provides a service in the marketplace, that's not the same as a organization like the Law Society that simply receives money and has to provide some services. So I think that the Law Society needs to take some very open steps directly with the members to reassure them that this new world of proper governance that was promised is going to come. Now, I would say also as a part of that, and we're talking about things that, that'll be discussed 2 years from now. I think the Law Society I think there is some mission creep there. I think the mandate of the Law Society has strayed from a focus of competence, making sure we have competent lawyers out there, and disciplining people who aren't competent. And I would say also this new problem that the Law Society is encountering is this turnover of generations, where there's the need to make sure there's succession planning in place, again, to protect clients. It's always about protecting the public. If we're not able to do that, then the idea of being a self-governing profession is in jeopardy. And I said during my venture campaign that there's no way, because I used to work for the Ministry of the Attorney General long ago when Ian Scott was Attorney General. And we talked about governance issues with the Law Society at that time. There's no way governments want to be responsible for lawyers. They spent all kinds of time, I remember when Mike Harris was Premier, all kinds of time getting rid of responsibility for certain things like real estate and business brokers, funeral directors, all of those things that used to be micromanaged by government were spun off into self-governing bodies that were then regulated, with a light hand from government. The last thing the government wants is to be responsible for the Law Society. But, I said that not knowing about this and whatever else has been going on down there. So it's things like this that do lead to people saying, hey, maybe we should be taking a look at their entitlement to self-governance. And to me, that would be a disaster for the profession. So,
JP, I think the next venture election that we have, I hope that people do remember what happened here. I hope people tune in and watch Convocation. You can watch the public portions on webcast. I watched the April Convocation, and a lot of the benchers who wanted to speak up about this scandal and address it directly with the profession were silenced. They were reminded that they cannot talk publicly about this, and it's got to be done in camera. The April Convocation opened with a speaker from the Trial Lawyers Association, I think, about the importance of civility. And Treasurer Wardle opened the meeting with, benchers must be role models in all respects for those of us who are licensees in the profession, that they must lead the way in civility and all that. Well, then be accountable for what happened here, as Michael says, and assure us it won't happen. So I think in the next bencher election, I want qualified board members as directors. I want qualified benchers. I want people with governance experience. I don't want them to get there and say, as God is my witness, how should I know how governance works? I have no idea how we approve salaries. I don't know how committees work. I don't know what they do. We asked the staff. They said, do whatever you want. So we did that. I want people with experience sitting on boards of directors. I want people responsible who are going to review the bylaws, who are going to understand their job, who are going to take it seriously, treat me with respect, treat my colleagues with respect. I don't want it to be a popularity vote. I don't want Bay Street firms ordering their associates to hit a button and thousands of people vote for somebody because of their position or their power or their popularity. I want qualified people. I want independent voices. I want representative voices represented by gender, by race, by law practice, by sole practitioners. I want people to have a proper, equal footing, level playing field. I don't want them getting together as little groups of friends or cliques. I think what happened last time was terrible. The optics were bad. It looked bad. It was toxic and disruptive for the profession, and it has brought us bad results, like the worst scandal in the history of the governance of this profession. So I want things to be better for us all next time and completely different, because right now they're still warring. If you watch Convocation, there are still factions. They are bickering, they're arguing, they're insulting each other, they're being uncivil. It is unhealthy. It's not good for the profession, and it all supports losing self-governance. So if we want to maintain self-governance, Let's do things differently. Let this be the beginning of reform in our election process, in our venture process. And we'll come out healthier, but the profession must stay engaged. We can't forget about this. It's not been resolved. We need to stay on top of them, be vigilant, and be unafraid to speak up. People are afraid of the Law Society. They're afraid of being audited. They're afraid of being disciplined. They're afraid of personal vengeance on the receiving end, which is terrible that that's how afraid people are and members are of our governing body. So we need people to be unafraid, to be critical, to be vigilant, to keep the pressure on, and have a healthier election process in 2 years where people are able to speak their own minds candidly and have candid, frank conversations, open dialogue about governing this important profession.
And I guess the last piece to look at that is looking at the governance going forward. And as Anita, you mentioned, there's been no, they've solicited feedback from, I think various organizations have made submissions, individuals, I made one as well, in respect to what should governance look like in terms of whether it's elections, size of the board, various committees, other involvement. Now, Michael, I don't know if you've looked at that, or if you want to just look at governance generally of the Law Society going forward. Anything there that, besides obviously the recommendations on the O'Connor report, but if you've seen anything in terms of restructuring the organization, and would a leaner board, have changed kind of access to information here? I mean, anything to add on that regard, Michael?
Yeah, a couple. I mean, I like what Anita said about the kind of people that should be running for bencher. I'm concerned about how we would construct rules around prohibiting slates and capping financing. I'm open-minded. I'd like to hear some things about that. If I just had a wish, I mean, you just wish that people like the ones that Anita described show up with their main focus being making sure that members are competent and ones that aren't competent are gone, and that we thereby protect the public. I don't want to sit around with a bunch of people, or I wouldn't want to sit around with a bunch of people who have agendas. That agendas lead to the conflict. And what we've seen in the past between these two slates are agendas arrived and clashed. And I'm not saying there shouldn't be healthy debate about differences of opinion, but we've seen the agendas clash, and the conflict that was created by that is what led to an environment where Jacqueline Horvath and others said, we can't go to convocation with this. That's what happened there. And this goes back to my question of why did they allow this to happen? They didn't want to go to a place where there would be conflict.
Yeah,
and
exactly.
The conflict was created by agendas, clashing agendas. So how do we stop that? I don't know. But I don't like the sound of the proposals I've heard so far about appointing people. And, this model has been around for a while. It used to work pretty well. It used to work with quality people from all over the province running for election, being elected. And yes, there was, groups got together and supported each other. I remember I started in practice in Ottawa, and I remember hearing about people running for bencher. And I thought, wow, that's really out of my league. I'm just a new practitioner. But I remember people coming to me and saying, here's a good person who's running for bencher. Let's vote for that person. I don't like the sound of the proposals that we've had so far, but I think that there's room for a good, healthy debate about this, and there is room for trust to be restored to the Law Society.
Just final thought, JP, on that. So this is exactly the problem. The problem is the current Good Governance Coalition and these proposals for reforming the governance structures. Their sole motivation stems from, as you identified, I think, at the beginning of our conversation, keeping the stop people out or whatever. Because what's happened now is the next number of vote getters as the 40 good governance people got in, or the lawyers did, as they're being elevated to the bench, the next number of highest numbers are from the other group, and they're creeping in, and now there's conflict within convocation. So it's to keep that out that they want to reform the whole way it's done. So instead of coming up with your next numbers, getting a seat, they want to hold by-elections every time somebody is elevated to the bench. And that's ridiculous. These by-elections are expensive, they're difficult, and whoever earned the next highest number of votes has earned the right. They've been elected. So the current system is fine. And you can't revamp the governance structure of a professional organization of 70, 80,000 members because you don't like a handful of guys that might have gotten the next number of votes. So the personalization, the politicization, the conflicture, the warring, it's all very kindergarten, respectfully, if you ask me. Like, this is not what you build enduring governance structures around. As
It's
Michael
like it's like a condo board.
yeah. Oh, yeah. 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 So, I mean, these proposals, I don't think a 54-member board is going to be particularly functional. I've sat on a lot of boards. I think, 10, 12, fine. I think 54 is a lot. But if you're going to reduce it, or even if you don't, I don't want to give this group of people the power to take away my vote and have these elected people replaced by people that they themselves would appoint. I don't want them getting their friends, more of their friends, put into those seats without me even having that vote to select my elected representative. So I don't see what it is about what they've just done now with Diana Miles' salary, the lack of transparency, the lack of accountability, the refusal to hold anyone who is involved in it accountable on the bencher side. I don't see what any of that is suddenly how it's supposed to give me and my colleagues the confidence in them now to say, you know what, I'll surrender my vote. You pick the people you want to appoint to sit there and make decisions. I'll trust you now in the wake of this to pick the people who are going to govern me. Not now is not the time for them to propose that.
I agree. And, just on one of the points on this, Anita, that you raised at the outset was people who are awaiting judicial appointments should not be benchers. And they should, if they're so great that they should be on the bench, great, go from private practice, but don't interfere with the governance of the Law Society because you're sitting there waiting for a phone call.
JP, Michael and I are having a violent agreement, I think, on all the things that we have mentioned.
Yeah, I mean, I guess then the piece that is what I mean, obviously there'll be a different composition of the board. However, it looks like whether it'll stay the same, or if any of these measures will go forward, and there'll be new elections. There may be then that new board will appoint people. I mean, what would you do differently then, right? If again, going back to if you were elected, Michael or Anita, at what point, right? I mean, in terms of changing the structure, in light now we have this sort of hot button issue that's galvanized the profession to say, look, what's happening here? How did that happen? The whys, everything, the from the whodunit, as you pointed out. Well, now we're paying more attention to who are the people, in between the election time. So, what should be done differently in terms of avoiding these issues from happening again? And what would you do, right, in terms of governance of the Law Society to avoid, as both of you pointed out, well, if this continues, maybe Attorney General Doug Downey says, okay, well, we don't really want to do it, but we're getting a lot of lawyers and paralegals writing to us saying maybe you should take it away based on what's happening here. So what can be done?
One model that I'm familiar with because of the time that I had in provincial government, working as a policy lawyer for Ian Scott. When Ian Scott was Attorney General, there were a number of reform proposals brought forward that I had a chance to work on with him. Family Law Act reform, class action reform, Environmental Bill of Rights reform, auto insurance reform. There were a whole bunch of active reform things that were needed to be dealt with. And they were dealt with through a cabinet committee system. And in some ways, I think that by looking at the way the province is governed as a model, you have a cabinet, you have cabinet ministers, you have parliamentary assistants, and you have smaller groups that feed into those decision makers. But everyone's participating, but the actual decision making feeds up to a smaller cabinet group, almost like an executive committee. And there isn't a loss of input by allowing that group to make a decision. There's a process that allows opinion to flow up, it's approved, and the decision making is made based on recommendations that flow up from the bottom. So there might be something in that, but the idea of, as Anita's saying, of elected people, getting appointed, and then the people who remain behind pick somebody to fill that spot. To me, you just end up with more of the same. You end up with people who agree with you. You're not going to pick somebody that you disagree with to fill that spot. So to me, that's a total non-starter.
Anita, how about yourself there? I mean, what other things?
I guess I would just do the direct opposite of whatever their current inclination is to do. Like I would have handled this completely differently. I think, we're taught as lawyers, if you make mistakes, assume for a minute this was a mistake rather than a conscious decision to do something against the rules that you were well aware of. One of the first things we learn as lawyers is we all make mistakes. So Lord knows I've made many mistakes. In terms of how and what we communicate to our clients about that, we're all taught, and I have tried faithfully, really to stay true to this. Admit your mistake as soon as you're aware of the mistake. Notify your client. There's a mistake. Be candid about it. I've made a mistake, and rectify it immediately as best you can. And there's, almost invariably, there's a way to rectify things immediately, as long as you're honest and you're transparent. We've seen none of this. So what would I do? And I would not gag the benchers. I suspect there are many benchers, and there's dissent, there are serious concerns about what's happened, why it happened, how it happened. Have a candid and frank conversation. Invite the profession in. Lay it bare and say, look, all of this went off the rails terribly. We recognized that the problem was the culture that led to this. They were afraid to come to convocation. They didn't want the conflict, as Michael says. And so we're going to create a convocation where there's no fear, where we tolerate dissent, where you can voice your opinion, where if you have a problem with something that's been done or being proposed, you can say so. I'm not seeing that when I watch convocation. Speaking for myself, I encourage others to look at that. But I think transparency, acknowledging mistakes, holding people accountable. If it were me, if I were part of what happened here, I would say, you know what, I was part of this. It's recognized. I made a mistake. Something terrible happened here. I'm going to step off for a minute while this is sorted and things are reorganized. I think part of the problem is that the individuals currently in these positions of power appear to me to feel entitled to stay there, regardless of what has happened or what the conduct is or what the results are. There is a sense of entitlement. There's a sense of we're better than. There's a sense of we are the benchers. We know best, and we're going to keep going. And we're not going to be held accountable. And we're going to, distract you by saying, we'll look at the rules again and hire an expert to revise the rules. But we're not accountable because we're entitled to be here, and we're going to stay put, and we're above it all. And that the profession can't handle that at this moment in time. So I would do things differently. I would be candid. I would ensure there's accountability. I would communicate. I would tolerate dissent. I would revamp the culture, make meaningful change, and commit to governing in a fair and equitable way with a vision and focus on the important issues instead of infighting due to personalities or ideology. These things are petty, and they're not mature behavior. We need mature governance that is transparent and honorable and smart and wise. And they should be telegraphing that instead of petty infighting and ideological clashes. We're sick of it. Does that help?
I think so, and I think perhaps maybe the last question here, we've certainly went past our time, but no, it was a great discussion. Is maybe Michael, any final words of wisdom, either for the benchers or for the lawyers and paralegals or those involved with the profession that may be listening? And again, there's that fear of the what can I say or can I speak frankly, or even the benchers, as Anita pointed out from watching convocation, are we allowed to discuss these issues because the better code of conduct or what might be there. So I mean, any words of advice to either the benchers or to those who are interested in this issue, who are concerned with the direction of the law society and how we as lawyers and licensees can control and shape the direction of our governance of our profession.
Yeah, I would say just two things. One, benchers don't need any advice from me. I think the people there know what needs to be done. They just have to do it. It's not like I'm going to give them some shocking piece of advice where they're going to say, "Oh, well, now I get it." They know what needs to be done. They just need to do it. But the other part I think is more important than that is that your listeners need to not be discouraged by this, because there is sometimes a temptation, like in politics generally, you want to tune out. It's too much. Like I got enough going on. I can't worry about this. Don't let that happen. As I was saying before we started our discussion, you know, I've been practicing for 45 years. I'm always concerned when I hear from members of the profession, especially younger ones, that it's stressful, that the mental health issues are getting them, and they're quitting. And I wonder, will they make it to 45 years like I did? My 45 years, fantastic. Sure, there were bad days, and yes, there were excellent days. Overall, fantastic. It's a great profession. It's a great career. Ontario's a great place to practice law. We have great judges. There are great lawyers out there. Um, don't let stuff like this discourage you from being involved in the profession, whether it's through the bar association or running as a bench or whatever. Get involved and stay involved, and don't let stuff like this get you down, because it really is important to roll up your sleeves and just do it. Plus, this is another part that's missing, and I guess this is a post-COVID fallout still, is we don't get to see each other that much anymore. I used to see each other in the hallways and the dining room, which I always thought was a fantastic place at Osgoode Hall to meet colleagues and meet judges, and just it was a real crossroads there in the dining room, and I really think we should bring that back.
Yeah, so you know
Plus,
what you know what you want to ask about that, Michael? There are 6 members. I went through all the committees of convocation to see what the committees do and who's on them. There are 6 members dedicated to the restaurant working group. And I want to know what the 6 members are working on and what kind of money they spent and what reports they've commissioned to reopen the dining room, which I agree with you. I'm from Toronto. I think you and I are both biased because we're in Toronto, so we could pop
yep,
down to Osgoode. We're in court in the Court of Appeal. We want to go to the lunchroom. I love that restaurant. I took my juniors there, the law students, give them a little treat. It was a beautiful meal. When they closed it, I cried. I wrote letters. We all wrote letters. But if you look at the committees of the Law Society, 6 benchers are working round the clock on that committee, on the restaurant working thinking tank group. And I want to know what they're thinking about. So what would I do different? I'd reopen the lunchroom.
good.
All
You got
right.
my
I don't
vote.
need 5 other benchers to sit around with me wringing our hands about how to deal with that beautiful empty space with the stained glass. You
Yeah,
give it to someone else to manage, or you whatever, but you give someone give the people a space to eat in this beautiful old courthouse from 1840. Instead, the Law Society has 6 benchers devoted to a working group, and I want to know what they're doing. I want to
yeah,
see the reports, the money. We need to get a better grip on what's happening with our fees, what they're using it for, what
yeah,
these decisions are that they're making. And I agree with Michael. Don't be discouraged. And you know what? If you have ideas, there are so many young people in this profession with energy and ideas and innovation representative of the bar. Run for venture, and I'll stand with you and your right to participate and be considered a serious candidate, whether you're part of a clique or a group or a slate or a coalition, or if you have buddies in the in crowd on Bay Street or you don't. I'll stand with you. I stood with you last time. I took a lot of flack for it, but let's hope for a new day where there's a chance for people with energy and ideas, innovation, who can help govern us in a way that we can be confident about in a transparent and fair way. Let's make the 2027 election equitable, fair, transparent, and let's not repeat what happened last time. Let's do everything we can to avoid it. Get engaged, become active. You have something to say. Don't just sit there being angry and upset. Come on JP's show and use it as catharsis to vent like I did.
Yeah.
Thank you for letting me do so.
Thank you both. Any final words from either of you?
Just thanks for the invite, and this is a public service, a professional service you're providing by creating the forum. And I was saying about the dining room, we do need more crossroads, for physical crossroads for members of the profession, whether it's a dining room or it used to be bar admission courses, the conferences that we would go to. We need to create more crossroads, and you've done it by having this program. So good for you.
Thank you, JP. Anytime that you would like me to come here and be angry about, anything, almost anything at all. It's a pleasure to meet Michael. I've not met before, and I really enjoyed the conversation. So thank you for the opportunity. I agree it's a public service, and thank you for the time and the energy that you invest in doing this for the profession. Thank you so much.
Thank you again to both of you. Thank you for anyone listening. And again, if benchers are listening, I mean, 2 years ago, I had like 60, 70 candidates, I think like 30, 40 of the benchers who were elected talking about what their platform is. But I know, I mean, I don't think that, as Anita and Michael have both brought up, that there are people who want to kind of share from the other side. Here's what happened. Here's why it's not so easy, Anita, to just open the restaurant tomorrow. Here are all the liabilities and things like that. But I think that is important. Whether it's with me, whether it's with some other podcast, or even yourselves. Maybe the Law Society should have their own little chat with the members. After every convocation, send out like a 10-minute like summary, and feel free to reach out to us, right? Because I think if there is better dialogue, we're going to feel more engaged of knowing what's going on, and as opposed to it kind of being hidden away. I mean, yes, obviously some stuff is in camera, but nonetheless, for any benchers, if you are listening here, I'd love to talk to you, or I'd love for you to talk to us, with whatever means of what's going on. So all the best, everyone. Thanks again, Anita and Michael, and take care, everyone.